2, my lord, the rules begin.
No, it's in which volume?
No, the judgment citation which has been handed over 15th and my lord, yesterday I have handed over the case. So,
this one.
yesterday I have handed, sorry my lord, for the yes.
Page?
At 232 rules begin, my lord. At 237 the relevant rule. 3, Roman 10, my lord, and 11. 10 and 11. Notwithstanding anything contained in these rules, the Commission may, in consultation with the government, adopt for purpose of recruitment in any particular case, class of cases, special procedure as more appropriate than the one prescribed in any of these rules. Then 11 says a decision as to the following shall be taken by the Commission in respect of all selections made by them, whether any candidate possesses the prescribed qualification, the basis on which marks should be awarded, the minimum marks and inclusion, all this this 2 covers or any other matter incidental to the selection. So the third evaluator being appointed will be covered by 2 and 5. And rule 10 has no application, and finding at para 351, which just now I pointed out to your lordships, 351 to 354. Your lordships may, your lordships go to the volume 3, 308. Yes.
Which rule?
If your lordship, 351 paragraph, 308.
Yes, yes.
Your lordship got it, minutes? Volume 2, 308 running page, internal page 208 of the judgment.
Yes.
Initially, in its web note, the Commission stated that 2 evaluations were mandatory, which was also reiterated in its counter affidavit. However, in the vacate stay petition, the Commission did not mention anything about the third evaluation, and later it filed an affidavit disclosing the implementation of the third evaluation. Being a constitutional body, while recruitments are taking place, the Commission must follow its own rules, strictly as mentioned in the rules of procedure under Rule 310. 310 just now, which I have read, has been extracted. The above rule indicates that if the Commission wants to introduce any new system regarding the conduct of examinations and evaluations, it must follow the procedure outlined in the rules for the direct recruitment process. Specifically, the Commission must first consult the government before adopting such a system for recruitment in any particular case. In instant case, Commission has never applied the aforementioned rule, and no specific rule has been prescribed for evaluation. There is no discussion in their argument. But this is ignoring Rule 311, which gives residuary power, which gives power to the Commission for conduct of examination and also evaluation. So that's how this is nothing but, and then whether the basis on which marks should be awarded, and in the answer script itself, which has been given to the candidates as a model, third evaluator has been provided. Decision as to the following shall be taken by the Commission in respect of all selections. 311 specifically provides, which also includes the basis on which mark should be awarded, any other matter incidental to the selection. So that's how reading 310 and said that any other rule which you wanted to change, you need to take the permission, all that doesn't arise. It is within the powers which have been given to the Commission under Rule 311, which has not been noticed by the learned single judge. Is my submission. Yes, yes. And then para 14 of my written submissions. Para 246 at 246 it has been said there is no evaluation at all. If the lordships look at 246, which is yesterday also I was page Page 250, minute para 246. But your lordship, yesterday, in fact, in a way I was referring to this, saying that one of the submissions made is there is no valuation at all has been done. Because in answer scripts, nothing has been noted on the margins. Now your lordship, para 246, while denying the submissions to the respondent counsel with regard to the evaluation process, the petitioner's counsel submitted that there is no indication of evaluation in the answer scripts is contrary to law. While supporting his argument, the learned counsel of petitioner relied upon the judgment so and so. He also submitted on similar circumstance, this court has repeatedly applied that ratio in so and so. Here by contrast, the total obliteration of the mock trial frustrates the very vigor of evaluation that these authorities deem mandatory. In the said case, the Supreme Court held that every examinee has a legitimate expectation that his answers will be looked at, appreciated and evaluated, and the resulting marking constitute the disclosable information. In the present case, there is no marking in any answer script, hence the above judgment support the contents of the petition. With great respect, I pointed out, but the first valuer gives the score and the answer sheet. Second valuer will be knowing there is no point in having the second value. Where more number of valuers are being appointed or engaged for correcting the papers, necessarily this moderation method is nothing to see that the second valuer does not know what the first valuer has given. Similarly, third valuer does not know what the first and second valuer has given. That purpose will be defeated, otherwise there is no point. And indication of evaluation on the answer script may not be there, but bubbling is there at page 1 for the evaluator 1 and evaluator 2 third sheet, third portion of the first page, and so for the third evaluator is concerned, page 3 which I have showed you. In the face of all this, but making an observation saying that this supports the contention because it doesn't show the evaluation. With great respect, this is nothing but, this is the reason why, having considered there is a moderation procedure, court still coming to the conclusion that there is no moderation, that direct, but following the Sanjay Singh's judgment. So that's where court went wrong is my submission. That's where court went wrong is my submission. And then and so far as number of candidates from centers 18 and 19, where only women have been allocated. Para 20 of my written submissions, your lordship sees. Percentage has not been calculated. But how many candidates appeared in a particular center is the criteria, Percentage has to be compared, saying that if at all if somebody is comparing. But para 365, if your lordships look at, percentage has not been arrived at. Without arriving at the percentage, in fact, ignoring what has been stated in the counter of the commission. But I can only rely upon the commission's counter, because we are not the persons those who have conducted the examination. Para 20 of my submissions I have elaborated, saying that these two centers, but 5.41% and 4.12% are these candidates selected out of the candidates those who have appeared examinations in center 18 and 19. But counter elaborates saying that there are centers where more percentage of students have been selected than these two. And 365 para 365 if lordships look at. May read this para 20 of my submission only. It is submitted the finding in 365 that 18 and 19 have unusually high number of selections, which is purportedly unacceptable, is perverse. Learned single judge applied an erroneous parameter of comparison. A more appropriate parameter to be applied was to see the percentage of candidates selected in a particular center out of the total number of candidates in that center and compare. The additional counter of the TGPSC makes it clear that the percentage in these centers was only 5.41 and 4.12%, which is comparable with the rest of the centers. This aspect has been completely ignored by the learned single judge. Secondly, the finding that the majority of the female candidates were selected from centers of 18 and 19 as compared to other centers ignores the fact centers 18 and 19 were only for female candidates, and there could thus be no comparison between those centers and other centers with both male and female candidates were there. And further, the fact that higher number of selections from any center is not proof of there being any wrongdoing, since it is also statistical probability, more so when there is no allegation, leave alone supporting material to indicate malafide or malpractice. Mere statistics cannot be the basis to invalidate. Even statistics is also not correct, according to me. If your lordships go to paragraph 365, 316 page. The finding is not with reference to the percentage. 365 at page 316. At page 316, bottom para 365. Lordships have got it, Mallet?
Yes.
The petitioner's allegation is that in center code number 18 and 19, highest female candidates were selected. To substantiate this, the Commission's Council produced a document number 1 with regard to the caption Group 1 services, mains examination center-wise overall, and female percentage of picked up 563 out of 563. Accordingly, their own document, female candidates were allotted to a total 28 center, out of which 18 and 19, 71 female candidates were picked up. It means on an average 35.5 girls per center were selected, whereas remaining 26 centers, 139 female candidates were selected. But without asking for how many female candidates were allotted, this parameter, each center 35.5 been selected, but how many? But if there are 1,000 students, those have been allocated to these centers. Percentage has to be calculated. This is not the method, which should have been adopted for comparison. In 139, 26 centers, how many female candidates are there is the criteria. That has never been looked into or arrived at. It means on an average 5.35 girls per center were selected. The figures show disparity between the average of two centers and average of remaining centers. Putting a question to myself, if 1,000 is there in one center, out of them 4% would be 40. But in another center only 40 students are there, 4% would be only 2 or less than 2. So this comparison itself is faulty. This is how yesterday I said, if wrong question is put, wrong answer will come. The percentage has to be referred, not with reference to the centers and how many candidates have been selected. 71 out of how many? While the counter of the commission gives 5.41 and 4.12 are the candidates, those who have appeared from center number 18 and 19 have been selected. These can never be the ground for setting aside the selection or interfering with the selection process, where there are checks and balances which are taken care by the commission. Yes. Yes. Para 23,
Council is on the issue, yesterday we could not furnish the figure, this commission, in 18 and 19, a total of 1497 female students appeared, out of which 71 got picked up.
That's what I am saying. Percentage is
1497 in 18 and 19.
How many got picked up?
71 got picked up.
But in fact, counter details, I am not taking much time of your lordships. In fact, the counter says several centers percentage of the candidates selected is much higher than this percentage of 18 and 19. There are several centers where candidates those have been selected from those centers, percentage is higher than these two. So there is absolutely no reason why. And in fact, Learned Advocate General also said if it is a randomization, because selection all tickets randomization, allotment of the centers is randomized. They said, learn single judge says if it is randomized, how only women candidates. That is giving the command to the computer saying that only women have to be given in 18 and 19 for the different reasons. For different reasons. That cannot by itself make the entire process of selection vitiated. That's the reason this example of 365 comparing these two centers with other centers where the women candidates were also there without reference to the percentage itself is faulty. Then yes. Para 23 and 27 and then I'll cite 3 or 4 judgments and relevant paragraphs only. I'll not take much of your lordship's time. Para 23 at page 9 These are the procedural aspects which have been noted by the learned single judge at page 279 of the judgment. Running page 279. And each of the points except one held in favor of the petitioners, but according to me, learned single judge has failed to give how these things have prejudiced the interest of the candidates, petitioners. Or the sanctity of the examination and the selection process is undermined. So that's what para 23 says, and then this is where I was saying paras 314 to 318. But if your lordship look at alleged allocation of examination centers in a biased manner, 285 if your lordships look at. At 314 if your lordships go to, the commission stated while allocating the examination center in a fair manner, they applied a randomization method. If the commission had followed the same approach, then how are centers 18 and 19 given priority only to female candidates? These leads all the petitioners to doubt the conduct of group 1 examination. The commission mentioned in a particular center 18 and 19, so and so, so and so. The college authorities themselves requested the commission to allot only female candidates with college. The commission to that extent they mentioned in the pleadings, but did not provide any documentary evidence. The objections of the petitioners were that once the same college was utilized for both male and female candidates in the UPSC examination, what insisted the commission to deviate from the system. The commission's action indicates that they did not follow the proper randomization method. The commission in their arguments now nowhere stated what necessitated giving priority only to female candidates. There is no proper answer from the commission. Moreover, they stated the commission prioritized the female candidate to protect their freedom. I could not get this from the pleadings. In fact, with great respect, what has been pleaded, as I remember from the commission's counter is, if male candidates are there, in those colleges, it will be difficult to provide for washrooms, for the males separately there. As these are the colleges, which are women colleges, so that's how, we thought fit to allocate only women candidates. That is the reason given. But where from this reason has come, saying that female candidate freedom, at least I could not see anything. This is not part of the pleading, subject to correction. The female candidates to protect their freedom. This is not the pleading, portion of any pleading, subject to correction. Always, when I say it is not there, I can't read the. No, in fact, counter speaks the details and reasons why. But this at least I could not see. If both the genders were allotted to the same college, security issues might arise. Under the same conditions, the commission prioritized the females. Though there is no rule in the commission's rule of procedure or notification to give priority to. What is the priority? Allocation to the particular center can never be said to be a priority. Only one category of people are being allotted. It's not priority. There is no priority as such. Commission's action amounts to violation of their own rules and procedure. And then, if the randomization, para 318, randomization method was used for allocation of centers, then how majority of the female candidates allotted to only 2 centers? It deviates from the meaning of the randomization. The purpose of this method is to minimize the selection bias, but whereas the commission acted against it. With great respect, as long as whose paper it is, and which center he appeared is not known to the evaluator. But all this will not take us anywhere. This is at the best creating some suspicion, mind, doubts in the petitioners, but that does not by itself is enough to interfere in the examination process is my submission. But there is no allegation saying that transparency has not been maintained and secrecy has not been maintained. Answer sheets have been given only with the barcode, not with the data of the candidate. So there is no way evaluator will be knowing the details of the candidate of papers which are being evaluated by them. So in that context, these findings will not. This is the ultimate conclusion with regard to this query. So all are like open-ended without there being any conclusion saying how each one of the procedural lapses which has been according to the learned single judge have taken place, which is not according to us, even otherwise, and nothing has been shown how it has prejudiced the chances of the candidates, and more particularly the petitioners. So, yes. The propositions from page 11 onwards, I will not bother to read and bring only few judgments I would like to, in addition to what has been cited yesterday. Page 11 of our written submissions indicate in para 32, 33, 34, these are the propositions saying that judicial review and the limitations how courts will not interfere, all this has been spoken to. Just I would like to, in fact, Tajveer Singh has also been cited, this has been distinguished by the learned single judge according to me, without there being a distinction. In compilation, judgments compilation, serial number 5. I've already brought to your lordship's notice the judgments. Judgment at serial number 2 has been brought to your lordship's notice. Division bench court judgment at 3 is similar to that, because when Supreme Court judgment itself is there, I need not trouble your lordships reading that. And Sunil Kumar has been already cited by the learned Advocate General. Then 5, your lordships, Tajveer Singh. It begins at page 81. Para 31, 36. Your lordships may just read only 3 or 4 paragraphs. Para 31 of this page 106 107. Lordships got it, pages. Before proceeding further, it is necessary to preface our judgment with the view that the courts in India generally avoid interfering in the selection process of public employment, recognizing the importance of maintaining the autonomy and integrity of the selection process. Courts recognize that the process of selection involves a high degree of expertise and discretion, and that it is not appropriate for the courts to substitute their judgment for that a selection committee. It would be indeed treading on this thin ice for us if we were to venture into the reviewing the decisions of experts who form part of the selection board. The law on the scope and extent of judicial review selection process and results thereof may be understood on consideration of the following case law. I need not trouble reading that. After referring to the case law from 32 to 35, para 36. Thus, inexplorable conclusion that can be drawn is that it is not within the domain of the courts exercising the power of judicial review to enter into the merits of selection process, a task which is the prerogative and within the expert domain of the selection committee, subject of course to a caveat that if there are proven allegations of malfeasance and violations of statutory rules, only in such cases the inherent arbitrariness can courts intervene. But in the present case, only one rule which has been cited, 310, being violated. In fact, 310 doesn't apply to the facts of the case, and 311 gives the power to the, which I have read to already to your lordships, the commission, residuary power to conduct the examination, the selection process and evaluation, everything. So that has not been noted. So except that, there is absolutely no violation which has been said to be made of any rule, and there is no arbitrariness. except using the word arbitrary and give rise to the doubt. Thus the courts while para 37. Thus courts while exercising the power of judicial review cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded by selection committee even in Viva OC. But in this case there is no Viva OC also. Subjectivity is minimized because of the fact that Viva OC is not their only written examination, are excessive and not corresponding to their performance in such tests. The assessment and evaluation of the performance of candidates appearing before selection committee interview board. But this is all with regard to the Viva OC. I need not. Even in spite of all that, courts have said interference should not be there. In this case, we are on a much better footing because there is no Viva OC. And then para 39. It is therefore tried that the candidates having taken part in the selection process without any dema. In this case, Land Advocate General has already pointed out to Lordships. But after the prelims examination, web note has been given to them on August 16-8 and examinations were held in 20th October, 2 months after, which indicates the procedure, how the valuation would be done and all that. And in spite of that, having participated, the candidates cannot approbate and reprobate at the same time. In other words, simply because the result of the selection process is not palatable to a candidate, he cannot allege the process of interview was unfair, even if it is interview or that there was some lacuna in the process. Therefore, we find that the writ petitions in these cases could not have questioned before a court of law rationale behind recasting selection. That is facts of that case. Recasting the criteria, even after recasting criteria, they participated. Now, having participated, they said recasting the criteria is bad. Court said, no, you can't do that. Then para 40, this court in so-and-so has noted that the only exception to the rule, a waiver in the existence of malafides on the part of selection board. In the present case, we are unable. In this case also, there is absolutely no malafides. And then, at page 134, serial number 7, Ashok Kumar Yadav, page 134, it begins, para 21, only one paragraph, I'll read, which is at page 164. But even, I need not read entire paragraph, in middle, page 165. Line about 4 from the top to save your Lordship's time, sentence beginning with, now it is true. Lordship's got it, extreme right hand side. Now it is true that some of the petitioners did quite well in the written examination but failed badly in the Viva OC test, and in fact their performance at Viva OC test appeared to have deteriorated in the comparison to the other performance in the year 77-78. Equally, it is true that out of first 16 candidates who topped the list in the written examination, 10 secured poor rating in Viva OC test and were knocked out of the reckoning, while 2 also got low marks in the Viva OC test but just managed to scrape through it to come within the range of selection. It is also true that out of the first 16 candidates who topped the list on the basis of the combined marks obtained in the written examination Viva OC test, 12 could come to the list only on account of high marks obtained by them at the Viva OC test, though the marks obtained by them in the written examination were not sufficiently high. These figures relied upon by the division bench may create a suspicion in one's mind that some element of arbitrariness might have entered the assessment of the Viva OC examination, but suspicion cannot take place of proof. We cannot strike down the selections made on the ground that the evaluation of the merits of the candidates in the Viva OC examination might be arbitrary. But here, everywhere it is said, it creates the doubt, creates the suspicion, and it is arbitrary. The procedure followed is not correct. It is necessary to point out that the court cannot sit in the judgment over the marks awarded by, even in interview, the marks are awarded where it has been shown. The candidates who top the list in the written examination, when they would get less marks in the Viva OC, even then courts, Honorable Supreme Court said it cannot be the basis, and it is proved or obvious that the marking is plainly, indubitably arbitrary or affected by oblique motives. So nothing is there, in this case to interfere with, no case has been made out, and this Ran Vijay Singh case has been cited by the Land Advocate General, relevant paragraph 32, my lord, I would like to read to your lordship, my lord. 32. It has been cited, no doubt, at page 229, my lord. Your lordship's, my lord, para 32, my lord, at 229. (217), my lord, the judgment begins at 229. It is, lordship's got it, my lords?
Yes, yes.
It is rather unfortunate that despite several decisions of this court, some of which have been discussed above, there is interference by the courts in the result of examination. This places the examination authorities in an unenviable position where they are under scrutiny and not the candidates. Additionally, a massive and sometimes prolonged examination exercise concludes with an air of uncertainty. While there is no doubt that the candidates put in tremendous effort in preparing for examination, it must not be forgotten that even the examination authorities put in equally great efforts to successfully conduct an examination. The enormity of the task might reveal some lapse at a later stage, but the court must consider internal checks and balances put in place by examination authorities before interfering with the efforts put in by the candidates who have successfully participated in the examination and the examination authority. The present appeals are a classic example of consequence of such interference where there is no finality to the result of the examination. Even after a lapse of 8 years, apart from the examination authorities, even the candidates are left wondering about the certainty or otherwise of the result of examination, whether they passed or not, whether the result would be approved or disapproved by the court, whether they will get admission in the college or university or not, or whether they will get recruited or not. This unsatisfactory situation does not work to anybody's advantage, and such a state of uncertainty results confusion being worse compounded. The overall larger impact of all this is the public interest suffers. So that's how, my lord, this has been cited by the Land Advocate General. I am not repeating, my lord. All these judgments are cited. All these judgments are cited, my lord, from page 11 onwards up to page 13, my lord. All the propositions have been given. Only to save your lordship's time, my lord, I have read only few of them, which will have direct bearing, my lord, on the issue. So in conclusion, my lord, there is absolutely no reasoning, my lord, which has been given to come to the conclusion that there is a need for, my lord, re-evaluation by adopting moderation. That is assuming moderation is not there, which is inbuilt. And then, my lord, if you don't follow that, examination has to be cancelled, is, my lord, nowhere. That's the reason, my lord, why the judgment under appeal, my lord, deserves to be set aside. Appeal deserves to be allowed is my submission. Oblige.
May it please, my lords. My lords, I appear for the respondents who are the successful candidates in the lead writ appeal 1066 of 25. Am I audible, my lords?
Yes, yes, you are audible, but Mr. Muralidhar is looking quite askance because he is today physically present. You said yesterday that those who physically present will have priority. So I was wondering.
I just take 15 minutes for the clock.
I said that for yesterday. If I can just hand up my 3 notes, which I had said I will give you yesterday, I have it ready. If those can just be handed up, my lords, I can just address you from there. I won't take long. A large part of it is already covered by the Learned Advocate General and by Mr. Reddy. So I'll just briefly take you through a little bit of the background. There are 3.
You can wait.
I can wait.
There are 3 notes. I'll just explain what the notes are, my lords, because I didn't want your lordships to wade through these written submissions in detail as far as I'm concerned. So if those 3 notes Ms. Pravalika can hand up. One note, my lords, your lordships will find it's titled as Note on Data. Your lordships should have 3 notes. One is.
So are they in 2 sets or?
There should be 2 sets, my lords. One for each of your lordships.
Each of it has 3 sets, my lord. I've clubbed it together. So it's 3 pages.
It's 2 single page notes and one which is 5 pages. if
Very well. So all three notes required for both of us.
yes, Lords. I'll just explain what the three notes are.
Put that clip. Otherwise, it will.
Yes, yes. Let me just give a background before taking your lordships to that note. Ever since the bifurcation of the state, which took place in June 2014, my lords, surprisingly and unfortunately and regrettably, this is
Just a minute. Let's see.
yes. Lords, ever since the bifurcation of the state in June 2014, it's unfortunate and regrettable that this, in fact, is the first round of the Telangana Public Service Commission's recruitment, which is coming to fruition. It's the first time. There was one round prior to the bifurcation, which was by the United States in 2011. But because there were objections at the preliminary stage, there was litigation. Eventually, it's only in 2016 that the mains were conducted separately by both the states, and the exam and recruitment took place. After which, my lords, this is not from my notes, I'm just giving a background. After which, in 2022, there was a notification issue. The notification was effective withdrawn because at the first stage, at the prelim stage itself, in the first instance, there was a paper leak. Then the second instance, when they tried to proceed with that preliminary stage itself, there was some issue with reference to the barcodes and biometrics of the candidates. So that 2022 notification itself came to be withdrawn subsequently. So now, for the first time in effectively 11 years, the state is finally managing to recruit, which is very important because the large number of vacancies in the state remain. The present notification which your lordships are looking at, I'm just giving you some figures. It covers 18 different services of the state, and the number of vacancies your lordships have already noted is 562. Now the three notes are handed up, your lordship will see. One is a one-pager on the data, because I think much of the data is relevant for understanding what the issue is at hand here. So the data is on a single page with the page numbers there to refer to it, so that your lordship will get a bird's eye view of what that is. The second is a one page again on the propositions. These are the propositions which place a heavy burden on the writ petitioners to actually invite the interference of a writ. My lords have that. I think my lord the Chief Justice is searching for it. It's a one page.
Yes, we have
proposition. Right. The last one is a chart on the findings of the single judge with our responses against each of it. I think both the Advocate General and Mr. Reddy have taken your lordships in some detail through each of this. So I will not be taking your lordships back to the judgment and para and verse on that. Your lordship may take it that there are these 6 issues with reference to procedural aspects and 5 issues with reference to the evaluation method. So those are the topics which are covered. I put it in one place so your lordship can know which para deals with what and what our responses are on each of them. Now, if I may, before I come to this data note, I just want to give your lordships what I believe might be the heart of this case. If your lordships were to examine the writ petitions that have been filed, and all these writ petitions were filed in 2025, after the results of the main were announced, I think one of the major problems here reminds me of that age-old axiom that no good turn goes unpunished. The Public Service Commission has made the mistake, perhaps, of being too transparent. If your Lordship takes note that at every stage the Public Service Commission was informing the candidates and the public about what they were doing. So once in August 2024, at the prelim stage, they put out what they refer to as a web note, indicating what the steps they are taking with reference to the prelims. The heart of this case, if your Lordship's notes, is a web note dated 13th March 2025. That date is very relevant because as the dates go, the mains mods were conducted from in October 2024, from 21st October to 27th October 2024. The evaluation was carried out from the 1st of November to the 31st of January, a full 90-day period in which 371 evaluators went through the process that has been indicated to your Lordship. 2 evaluators for every paper, except where there was a 15% difference between the two, in which case there was a reference to a third. All this is well established. On the 13th of March 2025, the Commission uploads a web note. This is well before the results. The results are on 30th March. They upload this web note, which you will find at page 447. I think it's volume 3, perhaps, page 447. Now, that web note details in para and verse the various numbers of evaluators across subjects, the steps that have been taken with reference to chief examiners, etc. They mention the number of centers, they mention the process that is being adopted, they go through everything in para and verse. This web note is treated by the writ petitioners as some sort of statute. They look at it as laying down some kind of rules and then filing a writ petition saying, you have departed from the web note. The figures in the web note show this as a departure with reference to number of those who took the final exam versus any previous press release of yours. It is merciful that the writ petitioners have not gone to the extent of saying that some of the tables that we wrote the exams on were of wood, the others were of steel. Because the absurdity, Manoj, I'm sorry to use this expression, but the absurdity of these arguments which they have taken goes to this extreme. If there was a font size difference between exam papers, they would have raised that as an issue. If you see just in that third note, Manoj, or just look at the headings in that chart which I've handed up, Manoj, just look at the headings. Issuing of different hall tickets for preliminary and main exam. My question is, so it applied the same to every single candidate who took this. What is the prejudice being caused on this? This is a point that both the Advocate General and Mr. Reddy have raised. But I am saying, with reference to every single one of these issues, the question that we should ask ourselves is, therefore, what is the sequitur of this? Issuing of different hall tickets for preliminary and main exam, allocation of exam centers, inconsistency in total number of candidates who appeared, which was easily explained because the High Court had on 25 candidates said that there is an injunction because they are sports candidates, because of which there was some discrepancy in the final numbers. Fourth, multiple evaluation of answer scripts. Fifth, publication of provisional or total marks list. Sixth, disclosing hall ticket numbers of unqualified candidates. And seventh, increasing vacancies by adding new vacancies. They anyway rejected the writ petitioner's argument. So on procedure, Manoj, these 6 points, every single one of them, the burden was on the petitioner to show what prejudice was being caused to any of them. Let us accept for a minute, because despite the fact that we have entire explanations for each of these 6 points, let us presume they are right. Let us presume the writ petitioners are absolutely correct on each of these 6 points. What is the consequence of any one of these? Merely because I have a different hall ticket. I have a different hall ticket because if your lordship saw, the Advocate General took you through the 2 pages comparing the 2 hall tickets. The centers are different. All the mains examinations plots were in the Hyderabad metropolitan area, in 3 specific areas of Hyderabad, Secunderabad. The prelims were across the state. So they had different centers which they had to print on the prelims. The mains mentions the hall ticket of the prelim. So you link the candidate. There's absolutely no problem with it. That's been done for the civil judges examination without demo. On allocation of exam centers, women centers were allocated because the institution said we want only women here. Our examination by the commission showed that they did not have men's washrooms in the women's colleges, therefore they had women allocated there. For people with disabilities, the argument was taken that look, it's on the 2nd floor, it's difficult to access. These, in fact, would have been arguments if we had allocated those centers to people with disabilities. That is exact opposite happened. There was a conscious sensitivity shown by the commission, which is why the commission allocated centers the way it did, by prioritizing the physically challenged, by prioritizing the women. These are perfectly in sync with Article 15 and what the commission is expected to do. For a minute, Manoj, if your lordships will indulge me, if I can draw your attention to the constitution, just a minute. Because we are not dealing with some subordinate authority, we are dealing with a high constitutional functionary. Article 315, Manoj. Just 2 provisions, Article 315 and Article 320. Article 315, Manoj, speaks of the Public Service Commissions and says, subject to the provisions of this article, 315(1), subject to the provisions of this article, there shall be a Public Service Commission for the Union and a Public Service Commission for the state. And then, if your lordship sees, clause 4, subclause 4 of 315, the Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of the president agree to serve all of any of the needs of the state. 5. References in this constitution to the UPSC or a state public commission, service commission, shall, unless the context otherwise requires, be construed as references to the commission serving the needs of the union, or as the case may be, the state as respects the particular matter in question. Now, my lords, Article 320. The functions of the Public Service Commission. My Lord Justice Mohyuddin Ali, it's the first clause, 320(1). Yes, clause 1, Article 320. It shall be the duty of the Union and the State Public Service Commissions to conduct examinations for appointments to the services of the Union and the services of the state respectively. So it is a solemn constitutional duty that they are discharging under the Constitution. Now, there are no acts or rules which are governing the field with reference to any of the points which have been taken by the writ petitioner. If the writ petitioner had to move to Constitutional Court under 226, the onus was firmly on the writ petitioner to say that, look, Constitutional Authority, Public Service Commission, these are the rules which you are breaching or violating against each of these parameters which have been referred to. Except, my lords, that one limited point where rules 15.1 and 15.2 were yesterday read out to your lordship, dealing with the publication of provisional and total marks list. In the chart, your lordship will come, it's serial number 5 in the chart. Except for that one, there are no rules at all referred to anywhere else. If there are no rules referred to, the Public Service Commission has the elbow room to evolve any method that it deems fit, provided that it is reasonable, non-arbitrary and non-discriminatory. That is what the Public Service Commission has done. All these first 6 parameters you find from the chart, they apply across the board to everybody. There is absolutely nothing discriminatory about any of the steps taken in this procedure adopted by the Commission. The Commission has perhaps been overzealous in disclosing to the world at large what the steps are that the Commission has taken. Yes. If your Lordship were to see the note now on data, my lords, which I had handed up, just so that you have an idea, my lords, of what this exam entails. That note on data, 1 page. First segment is dealing with candidates. Right, bro? So 3 lakh candidates. I have given the reference of the page number so your Lordship can find it. The TGPSC WS is the written submission to the Public Service Commission. So 3 lakh candidates appeared at the preliminary stage. Of these, 31,000 qualified for the mains. Of that 31,000, 21,110 sat for the mains exam and wrote all 7 papers. The total number of women candidates who sat was 6,396. Your Lordships may make one note here. If you look at serial number, serial number 18 on the same page, you will find number of candidates in centers 18 and 19. My friend had just given your Lordship the number earlier this morning. Those are the women candidates, 721 and 776, totaling 1497. Please read this with serial number 4, because 1497 out of 6396 sat at these 2 centers. So much larger proportion of women were there at these 2 centers because this was the Women's Institute Center, and therefore even as far as scoring, as far as topping, as far as women candidates are concerned, all of them would be proportionately much higher at these 2 centers. This is just a data point. Now, yes. Serial number 5 are those whose marks were included in the total mark list that your Lordship will notice from 21,110 from serial number 3 has shrunk to 21,085. This, as the Imperial Judgment notes, is because there was an interim order by the High Court with reference to 25 candidates because they had, I think, some other issue regarding sports, etc. So the final number is 21,085. Of those 21,085, those who got the qualifying marks are 12,622. Serial number 6 will go with serial number 15. Serial number 15 provides a cutoff for those who qualified across the various vertical categories. 360 are open category and EWS, 315 OBC and 270 for SCS. So this is the 12,622 who got the qualifying marks. Selected pursuant to the mains exam is 563. Of these, English 12,381, lion's share of that. 8,694 is Telugu and only 10 is Urdu. Because there were only 10 Urdu candidates, rather than getting into an evaluation process which required details regarding Urdu, they said, look, it's only 10, so we have evaluated it separately as far as 10. Much of a song and dance was made about the fact that, oh, you have not applied the same parameter to English and Telugu and Urdu. I'll show your Lordship that from the judgment. Now the subjects, your Lordships may note, the subjects are, English is the qualifying exam. So they do the English, this is that part of the mains. They do the English exam. Out of the entirety who took the mains, my lords, of 21,000 odd, 924, your Lordship may note this, it's not here, 924 did not make it through the English exam. English is the compulsory qualifying paper for everybody who sat for the mains. So 924 did not make it past English. One of the points taken by the High Court is that if there were 924 who did not qualify, why did the Public Service Commission go ahead and evaluate the remaining 6 papers? which are the papers which will be reckoned for the purposes of the mains? The answer to that is simple. Because if any of these candidates had asked for reevaluation and they got their chin above the cutoff mark, then they would have qualified. Then we would have to undertake the process all over again of evaluating those 6 papers. Might as well just do it for everybody. The separate 6 papers are the ones on which, my lords, the evaluation is done. Evaluation does not include the compulsory English paper. The remaining 6 papers are given in those 3 mediums. You choose English or Telugu or Urdu for your 6 papers. The details of those 6 papers, your lordship will find at page 383 of the appeal. The details with reference to Telangana, administration, it's all general studies. All 6 are general studies papers. 150 marks for each of those 6 papers, which totals to 900 marks. Out of those 900 marks, my lords, serial number 13 will show you that the highest mark scored was 550. The median mark which was scored is 369. And the cutoffs your lordships will find. Now, as far as the examination itself is concerned, there were 46 centers, 3 of which were women's centers. The average number of candidates in each center was 459. Women, of course, those 2 centers was an aberration because there were only women and there were more than 700 in each of them. And the total number of evaluators was 351. Much has been made, if your lordship will see, with reference to the selection of evaluators in the single judge's judgment. Just 5 paragraphs devoted to why the Public Service Commission got it wrong with reference to evaluators by entirely relying on one single evaluator, who the Advocate General showed your lordship yesterday. That evaluator had in fact provided some assistance to a coaching center more than 10 years ago. He has filed an affidavit in this court showing actually that his relation with that coaching center had come to an end many years ago. And in any event, let us presume that even if he is linked to the coaching center, what is the consequence? Have you found that there has been any bias or favoritism when you don't have the names or identities on that answer sheet? You only have a barcode which will have to go back and be scanned and be identified so that the results can finally be declared. Based on this one bold allegation regarding this gentleman, unfortunately, the High Court has come to a finding saying that the process of the evaluation with reference to the selection of the evaluators has been undermined. Just looking at Dr. M.A. Malik. Now, my lords, your lordship can keep that note aside on the data. That's just to give you an overview. Now, the propositions note, if I can trouble your lordship with. We have a compilation of judgments. We put all the judgments there in one place. It's fairly bulky. I'm just going to trouble your lordship with one of those judgments. But the copies of the compilations are there. It includes what was handed up yesterday by the Advocate General. I think Sunil Kumar's loose copy was handed over to your lordship. We have put it all together in one place. But if I can take you to the proposition note, there are 4 basic propositions, and I think the law is squarely in our favor on this. The first one is that as a constitutional authority, the discretion of the Public Service Commission ought not to be lightly interfered with, especially when the Commission has evolved a non-discriminatory procedure. The procedure which even the writ petitioners admit is clearly non-discriminatory. The parameters which have been evolved are fair across the board and there is no problem found with it. The presumption then is in favor of the Commission. The only way that presumption can be dislodged is by showing that some rule has been violated. In the absence of a violation of a rule, the presumption is that the Commission's actions are non-arbitrary and non-discriminatory and they can follow whatever procedure they want. Yesterday, your lordship saw in Sunil Kumar, they say that look, the precedent that has been laid down in the past in Sanjay Singh is not a binding precedent. Moderation is perhaps the way to go, where everybody takes the same 6 papers, which is the case here. Everybody has taken the same 6 papers. The medium doesn't make a difference. So Sanjay Singh to that extent applies. Moderation is what has to be followed. And I adopt what Mr. Reddy said before me, that the method that has been followed here precisely with having two evaluators is moderation. It's nothing but that. But even then it's not binding. Even if they're not followed moderation, Sunil Kumar makes it clear that you have to follow something which is reasonable. And this is something which is reasonable because it is applied across the board, fairly, without any discrimination of any sort. So that is the first proposition. We have mentioned the judgments with the para numbers. There's also the High Court judgment in Vinod Kumar versus Jharkhand, where it was taken in SLP and that's been dismissed. It's all part of the compilation which we have just handed up. The second is that if the court were to interfere, the court must be shown that there is a grave irregularity. It's not enough for them merely to allege that there is an irregularity, it must be proved. Much like the Advocate General yesterday, Malon, even I am scratching my head trying to find out what is this grave irregularity. Forget about proving it. What is the grave irregularity according to them that has been occasioned here? Because the nature of the allegations that they have made from their own petition and the findings of the single judge about disclosing hall ticket numbers of unqualified candidates or having two hall tickets, or some centers had people who are more successful, that in itself doesn't in any way satisfy the requirement of a grave irregularity, leave alone it being proved. Third proposition, after such grave irregularity is proven, it must prevent the entirety of the process so as to vitiate the entirety of the selection. Because their plea, and that is why this latest writ appeal has been filed, is that it is not enough to have a re-evaluation. We want the entire results of the mains to be set, which if you saw the directions, Manoj, it's an alternate direction of the single judge. The entirety of the mains should be set aside. I agree with Mr. Reddy, it's entirely contradictory for such a direction to be given at all. But in any event, if that is the plea, what do you have to back it up? The reason I say this, my lords, is that in the Vanshika judgment, which I'm going to take your lordships through, which forms part of both propositions 2 and 3, Chief Justice Chandrachud's judgment deals with where there was a leak of the NEET exam, an All India exam, and there was a leak. Admittedly, no allegation, not a single allegation here in these proceedings, leave alone a leak, of any malafide, any wrongdoing on the part of the commission, a paper setter, an evaluator, a examiner, a supervisor, an invigilator, nothing, not a single allegation against anybody. In that kind of an extreme case, where the Supreme Court was told, admittedly, Mr. Tushar Mehta, the Solicitor General, said there has been a leak in the NEET exam. And the NEET exam leak had happened in Godhra in Gujarat, and it had happened in Bihar and Jharkhand. Despite which, the court lays down a threefold test, applies the threefold test, and says, yes, even where there is a grave irregularity, even where there is malfeasance which is admitted, even where CBI is investigating it, even in such a case, we will not set aside the exams and the results. Even then, because it is not pervasive, it has not undermined the entirety of the process. Even then, I had occasion, in fact, recently, Manoj, all the public services commissions in the states, wherever they are conducting it, invariably there is being challenged. One way or the other, it's being challenged, it's going to court. So I had the occasion 2 months ago to assist the High Court of Jharkhand at Ranchi. And we succeeded in a case where there was an allegation of paper leak, where the unsuccessful candidate got to try and set it aside. We have put that judgment of the High Court in this compilation, I think, where once again the Vanshika principle was applied and said, let us even presume that something is to be investigated. But unless you are able to show that it's pervasive and it is undermining everything, there is no question of setting it aside. And finally, Manoj, the last proposition, which is what many of us are pitching our tents on, which is any allegation regarding the procedure or the evaluation ought not to be entertained unless the prejudice is shown to have been caused to the writ petition. I'm not going to take your lordship through the judgments below. I've given you the citation and the para numbers. Your lordship may refer to it. We are short of time. So these are the 4 propositions to be borne in mind. Now, keeping these 4 propositions in mind, below, if your lordships would take a look at that chart on findings once again, bearing in mind, below, that these results are drawn out of 6 exams of 150 marks each, which candidates have finally had an opportunity to sit for after 10 years. If there were any interference, many of these candidates, one generation has already gone without having an opportunity to take the exam. The second generation is now trying to take it. If this is set aside, again there will be age bar. It will be a third generation in Telangana who will have to take these exams. Now, if you were to take this chart and see what these issues are, the procedural aspects.
That perhaps you did not labor because that has been always two aspects.
Your lordships are right. So the first 6 points on procedural, I will take it as read. Just please note, I have some supplementary points on each of them. It's in the last column, my lord. I won't read it out, your lordship. Just please note that on each of which there are supplementary points. I will just draw your attention to serial number 5 for a minute, which is where those paras of the notification have been referred to, 15.2 and 15.3.
Yes.
Which the High Court had occasion to explore, and they had extracted that. For a minute, if I can trouble your lordships with the High Court judgment, para 323. Para 323. I'm only addressing this because this is the one rule or norm that they claim there has been a violation of. Nowhere else is there a rule or a norm that has been violated. It will be page 291 of the appeal. It's para 323, where these rules are extracted. Manoj, have that?
Yes.
Yes. Manoj, 15.2, rule 15.2 of the notification is extracted, and 15.3, if I can just read that for a minute. 15.2, the mark list of main examination, total mark of all the candidates will be displayed on the Commission's website. However, paper-wise memorandum of marks of all candidates can be accessed in their respective logins for a period of 1 week. So, the total marks across all 6 subjects out of 900 is displayed on the website. But the individual marks in each of the 6 papers is not available for me to compare one candidate with another. Individual is available to me in my login. There is absolutely nothing wrong with this. This rule is not under challenge. They have fully fulfilled this rule. This rule is exactly what is followed in NEET. Last week, about 10 days ago, the CLAT results came out. It's exactly the same in CLAT. You don't get to see how much you scored across each segment and how other people fared. You get to your login, your mobile number, an OTP is sent, you access it, you get to see your marks, that's it. Now, if you feel that your marks are much less as based on the model answer key, then you make the representation, and within that time period, they will rectify or address it. It cannot be an argument that because I don't find my colleague's marks, therefore there's a discrimination. This is what is followed across the board. Rule 15.3, which is below, request for recounting of marks will be considered for conventional type only within 15 days after publication of provisional list, etc. etc. If you see next para 324, it gives you a flavor of how the single judge is approached it. The commission, as per the other rule, ought to have published the total marks of all candidates along with provisional subject-wise marks. Where is this along with being obtained from? 15.2 doesn't require it. Without doing so, the commission sent individual subject-wise marks to the individual logins, which is incorrect, arbitrary, and violative of their own rules and regulations. It's precisely in keeping with the rules and regulations. The rule says individual marks will not be displayed. Only the total marks will be displayed. So I think the single judge is entirely in error in this, and there is no violation of the rules. Coming back to the chart for a minute, Manoj, therefore, all these 6 points on procedure, there is no violation of rules except for this one claim, and there is no prejudice being caused to the writ petitioners in any one of the 6. Now, if you look at evaluation, selection of evaluators is pinned on one M.A. Malik and what he did. This out of the total number of 351 evaluators, one has been chosen as a stray for this purpose. The single judge notes that out of 351, 2 were retired, only 2. And the single judge's finding, I thought I should clarify this to your lordship. The single judge's finding is premised on the language employed in that web note I referred your lordships to, the 13th March 2025 web note says, and this is a web note, Manoj, they're just giving an update. They say the evaluators are all in regular service. So the writ petitioners say, you said regular service, 2 of them are retired, therefore those 2 are not in regular service, therefore it's a violation. Without explaining what the prejudice is. It's possible that Mr. Malik had not evaluated any of their papers at all, we don't know. Because there were 351, because it was anonymized. But they have taken this web note as some sort of sacrosanct rule or regulation and said, you said it's regular service. These 2 are retired, therefore you have violated your rules. It's not a rule, it's just a notification for the sake of transparency. If they had known, perhaps, the commission, that this was going to be used as a statute, they would perhaps have been more careful. They would have said 349 who are in regular service and 2 who are retired. They would perhaps have said that. The procedure of evaluation, I think that's point number 9, serial number 9. The entire process, your lordships may note, because this is what is the process which even Sanjay Singh talks of, that what the moderation process should be. That entire process, if you see the last column, your lordship, just note those 3 pages, 933, 934 and 447, 448, 4 pages. Both in the web note and in the affidavit of the commission, they mention exactly in terms of Sanjay Singh, how there is a chief examiner, how they moderate it to ensure that there isn't that kind of difference across the marks being given by the evaluators, etc. And what are the safeguards that they have in place. And I was perfectly in keeping with Rule 311 of the abuse of procedure. They have the elbow room anyway. Points 10, 11 and 12 again show absolutely no prejudice at all to the expedition. Telugu medium candidates, not one Telugu medium candidate is among the writ petitioners. Please note that, Manoj. This is an academic exercise the court is being invited to take upon. No unsuccessful Telugu medium candidate is a writ petitioner. The successful ones have succeeded. The numbers cannot in any way be determinative because it's a proportion of whoever is chosen which has
You'll have to call him to
Yes.
reconnect.
I'm sorry, my lords. Can my lords hear me?
Yes, yes. Now
I'm sorry, my network just dropped. One of the problems which I would not have faced if I was there. Well, so I was saying that, so none of the Telugu candidates have made the complaint. As far as the point, serial number 11 is concerned, which is that the highest qualified candidates are in specific centers, this is factually untrue. The success rate is between 4 and 5% across the various centers. and the same marks have been awarded to certain candidates. Clause 12.3 of the notification, which I mentioned to your lordship yesterday, which provides for the tie break. In fact, it provides for 3 levels of tie break, not 1 but 3 levels of tie break. The first is where they look at the whether they are local candidates or not. Then, if they're still tied, they look at date of birth. If they're still tied, they look at their scores in each of the 6 exams and whether each of the exams, first exam 1, exam 2, exam 3, would break the tie. I'm sorry, I've just been corrected on instructions that there are some writ petitioners who are the Telugu medium writ petitioners, so I'll correct myself on that. Despite there being some writ petitioners who are Telugu medium, no data has been provided by them as to why that could possibly be bias, etc. It must be because of the choice of language and the manner in which the subject was addressed by them. And the Public Service Commission, the Union Public Service Commission had also conducted, the Andhra Pradesh Public Service Commission had also conducted a similar exam in Andhra, and the proportion with reference to Telugu as against English medium has remained the same even in Andhra. So there is that much of a discrimination. Just one last thing, and I'll conclude, Manoj, is this, that yesterday, your lordship shown the Sunil Kumar judgment, which was handed up to you, and the learned advocate general had taken you through it. Just one paragraph of that, which I think he read only till para 20. The latter part of para 21 may be relevant. Your lordship may just note it, because para 21, it was a loose copy that was given to your lordship yesterday. If it's not possible to locate it easily, if I can just say that the last part of para 21 has a separate proposition. I'll just read that out to you. Para 21 of Sunil Kumar, which is 2016 to SEC, at page 506. It says, also, the absence of any plea of malefides and the uniform application of the principles adopted by the Commission by its resolution dated so and so would lead us to the conclusion that the present would not be an appropriate case exercise of the power of judicial review. The absence of reasons or in the aforesaid resolution on which much stress has been laid by itself cannot justify such interference when the decision on scrutiny does not disclose any gross or culpable unreasonableness. So in Sunil Kumar Maloj, apart from the fact that the moderation aspect was considered, and they said that the moderation is not binding from Sanjay Singh, they also said that because you have not made a plea of malefides and we have not found any gross or culpable unreasonableness, we will not interfere with the process. That's the last part of para 21, it was not read. And finally, Malaj, Vanshika, in this compilation which I have handed up to you, Malaj, I'm just showing this because this is an extreme example. It's an example of a paper leak of a national exam like NEET at page 406, Malaj. That's where that judgment starts. We have an index of propositions, etc. Your lordship can skip that and come to page 406. This judgment has been substantially followed across the country, and I'll just take your lordship through some of the paras of this. My lord has page 418, that's where the judgment starts, the background of the judgment. 418, the printed page 418. My lords have para 4. Para 4, this year NTA opened the online portal for NEET. NEET was conducted on so and so with over 23 lakh candidates at so many centers and cities. the exam was also conducted overseas. Soon after the exam, it became known that the question paper was leaked or illegally circulated among some students prior to the conduct of the exam at Hazaribagh in Jharkhand and in Patna. FIRs were registered in multiple states, and they mentioned all the states. And then my apologies, Manoj. Am I audible?
Yes.
I'm so sorry. So, para 4 gives the background. Para 7, Manoj, are the prayers and the writ petition. To show you what was being considered by the court. And the prayer A was for a fresh exam. B was to stay the counselling process. G was to direct it to correct and republish results, ranks, percentiles. So effectively similar prayers as what was made here, Manoj, to completely reevaluate, set aside the exam results, etc., etc. If I can just show you para 10, Manoj, because these are the 3 parameters which are referred to as the litmus test. At the bottom of page 419.
Yes.
By its order dated so-and-so, the court noted the central submissions urged on behalf of petitioners. It observed that the question of whether the paper leak was confined only to Patna or extended across cities was a matter which must be reserved for more detailed consideration. It's also noted that the litmus test for whether a retest ought to be directed was based on the following aspects. A, whether the alleged breach took place at a systemic level. B, whether the breach was of a nature which affected the integrity of the entire examination process. C, whether it was possible to segregate beneficiaries of the fraud from the untainted students. This C, Manoj, and B would both be in the event that there is a breach which is established at all. In our case, we are at a threshold much before this. We are unclear as to what this breach is that has been alleged. Therefore, once they the breach, then they have to prove it. Once they prove it, they have to show that it's at a systemic level, that it affected the integrity of the entire process, and whether segregation is possible between tainted and untainted. Now, the court, after looking at this, I'll just come to where the findings are. It starts from para 62. Para 62, which is at page 433. The court had in fact passed a brief order on that same date to declare the results, saying no interference is called for, and this is the detailed judgment supporting that. So para 62, after noting that in fact there is a leak, para 62, the facts of this case and the resultant issue before this court do not call for the development of new legal principles. It is settled law that the cancellation of examination, either for the purpose of gaining admission into professional and other courses, or for the purpose of recruitment to a government post, is justified only in cases where the sanctity of the exam is found to be compromised at a systemic level. Courts may direct the cancellation of an examination or approve such cancellation by the competent authority only if it is not possible to separate the tainted candidates from the untainted ones, please come to para 72, my lord. Para 72, I'm not just reading the other because there's a lot of reference to past case law which they through. Para 72, that the question paper was leaked and some candidates indulged in malpractice is beyond cavil, so they accept it. No party before the court, including NTA, disputes this. The question, however, is whether this leak was systemic and of a nature as to vitiate the sanctity of the exam. There are various aspects in this case which require the reconsideration of the court, the consideration of the court. The inflation of marks and ranks, the leak of the question paper, other forms of malpractice, the reopening of the registration window, the change of when the form was opened for correction, and the award of compensatory marks to 1563 students. These are considered in turn. Now, these are all additional allegations in addition to the question of practice and paper leak. They look at each of these points. Each of these are sought to be brought home by the writ petitioners there. And at para 79, they look at the data points from para 73 onwards, all the way up to 78, and at para 79. From the above figures, it becomes clear that there are no abnormalities in the results of 2024 when compared with the results for the past 2 years. The report of Director IIT Madras also supports the conclusion. The report stated that there were no abnormal indications in the results for this year when compared to previous years. It also stated that analysis shows that there is neither any indication of mass malpractice nor a localized set of candidates being benefited, leading to abnormal scores. Hence, an analysis of the results does not lend support to the case of the petitioners who seek the cancellation of the exam. The leak of the paper does not appear to be widespread or systemic. It appears to be restricted to isolated incidents in some cities which have been identified by the police or are in the process of being identified by CBI. And para 86, finally, para 86.
Yes.
Hence, sufficient material is not on record at present, which indicates a systemic leak or systemic malpractice of other forms. The material on record does not at present substantiate the allegation that there has been a widespread malpractice which compromised the integrity of the exam. To the contrary, an assessment of the data indicates that there are no deviations which indicate that systemic cheating has taken place. The information before us at this stage does not show that the question paper was disseminated widely in social media or the internet, or the answers were communicated to students using sophisticated electronic means which may prove difficult to trace. Students who are beneficiaries at Hazaribagh and Patna are capable of being identified. CBI investigation reveals the number of students who are the beneficiaries of malpractice at these two places at this stage. This leads us to conclude that it is possible to separate beneficiary of malpractice or fraud from the honest students. This being the case, the court cannot direct a re-exam. I won't trouble you with the rest, but the upshot is simply this: that in case where there is a paper leak, where it's established malpractice, where all of this is admitted, in such an extreme case, the court still says, let us see whether it's pervasive, let us see whether it has undermined the integrity of the entire process. Unfortunately, my lord, the single judge here has raised ghosts which do not exist, accepted them as stated by the petitioners without following up as to what the sequitur is, whether there are any consequences for the entirety of the exam. I am afraid the judgment loses sight of the fact that in 10 years, this state has not been able to avail the services of individuals who are now serving them, thankfully. And this perhaps is not the kind of case where the petitioner has been able to demonstrate even a single instance of any type of wrongdoing. It's my submission that the single judgment is entirely wrong and needs to be set aside, and these candidates allowed to be continue to function. I'm very grateful for a patient hearing despite me being online, and my apologies, my lords, for the twice that the network went. I'm very grateful.
Yes.
Well, I'm fully conscious that we should be repeating points, so I think elaborately points have been covered by the learned AG, Mr. Prakash Reddy and Mr. Shankar Narayanan. I want to start with the operative portion of the single judge's order. I think that has also been dealt with by the AG, but I just wanted to add a few things there. After this elaborate exercise that the single judge took, it appears to me, Malas, and with greatest respect to the learned single judge, that the single judge was in a quandary. What is the kind of relief that is supposed to be given? Because on the one hand, the single judge finds this evaluation process problematic, which of course has been demonstrated was fully within the remit of the commission. But in the conclusion at page 320, the running page 320, para 369, this court, after analyzing the submissions of all counsel, case law and material available, this court feels that the commission, while conducting the group 1 mains, has not maintained transparency, which is completely untrue, my lords. Integrity, acted in a biased manner and deviated their own rules. Each of this is wrong, my lords. Each of this is a mistake. Transparency, nobody can even doubt there is total transparency. I'm sorry to be just adding to one clarification was that page 447 Mr. Shankaranan referred to is a press note. It's not a web note. 3 days prior to that press note, there was a web note, because I'm sure this is going to be argued by the other side. I'm just clarifying the correct position. The web note is 10th March 2025. The press note that Mr. Shankaranan referred to is 13th March 2025. This web note,
Just a press note is off.
press note is 13th March, that page 447 that he referred to, that is a press note, 13th March. 3 days prior to that, there was a web note. Because this also has been adverted to in the learned single judge's order, I thought I should point this. Now, in this web note, which adds to the transparency, not deviates from transparency, the second paragraph is important, second and third paragraphs. As per para 15 of the notification, my lord has that.
Yes.
Candidates can apply for recounting of marks. Lordships underline the word recounting. Candidates can log into the TGPSC portal, enter their credentials for recounting of marks. Then it says for recounting of marks, candidates have to pay 1,000 rupees for each paper through online payment only. The request for recounting shall be submitted only through online. Offline requests will not be considered at any circumstances. The next paragraph, para 15.5, rejected, invalid, disqualified, ineligible candidates will not be issued any memorandum of marks, and fees paid by the candidates, if any, will be forfeited to the government account without entertaining any correspondence in this regard. The next line is important. Request for re-evaluation will not be entertained under any circumstances as per Rule 31139D of the Commission's Rules of Procedure. Now, this rule, I don't know whether lordships have been pointed out. This rule is at page 245 of the written submissions. Yes, written submissions of Mr. Prakash Reddy, Malaks. That rule begins at
Page 245.
Yes, ma'am. Yes, 245, Rule 3, and the relevant, it's Mr. Prakash Reddy's compilation. The relevant portion is 247. And clause D, sees clause D, 9D. There is some English problem alerts, because if your lordship sees 9, the commission shall, A, B and C goes with commission shall, but D starts separately.
Perhaps the compilation of Mr. Reddy is over in.
Well, your lordship sees the commission's.
That would be.
Or give me Prakash Reddy's page. Lordships have it once.
The commissions.
Commissions.
Then which volume and what page?
Your written submissions, page 215.
PDF page. 247. Yes.
D, yes, revaluation.
Well, sir, re-evaluation of answer sheets shall not be entertained under any circumstances. The point I want to make is, Malas, this rule is not challenged. As Mr. Reddy was pointing out, they could not have challenged having participated in the exam, but assuming at this stage they want to say this is an arbitrary, unfair rule, they have not challenged it. The writ petitions have not challenged it. The learned single judge is aware of this, and yet in the operative portion says it will be sent back for again the examiners to look at it. I mean, how is this even possible? On the one hand, he is finding fault with the commission of not having complied with the rules. Here, this operative portion itself violates this rule. So, what you could not do directly, you could not have asked for evaluation. Through a writ petition process, on vague grounds, you get the same result. The second point I wish to make, my lords, is this. On the two hall tickets, it's very strange what is weighing with the learned single judge if your lordship turns to page 281, para 307. And there's some fundamental conceptual error. And I'm glad Mr. Shankar Narayan referred to articles 315 and 320 of the Constitution. Please see para 307.
Yes.
After reviewing the Commission's explanation that regarding its administrative feasibility, they adopted the said procedure. For this type of direct recruitment, the Commission has to follow the Telangana State Public Service Commission's rules of procedure. In the said rules, nothing was stated regarding the issuance of two hall tickets. Further, the procedure followed by the higher commission. There is no hierarchy here, with the greatest respect. The learned single judge seems to think, oh, UPSC is the higher commission. All these state commissions are, somehow subordinate to the UPSC. So that should be the standard. With the greatest respect, completely conceptually wrong here, brothers. Conceptually wrong. And this is where he's got completely led astray. Because I don't want to again repeat this, two hall tickets is not even prohibited. What he should have asked is, does anything in the rule prohibit it? Instead of asking, does it permit it? It's not etched in stone that there can be only one hall ticket for an exam. Where does he get it? Then on this web note, an elaborate argument was made, this web note which I handed over, saying, why did you publish? Mr. Shankaran has dealt with it, why did you evaluate? They say, why did you even publish? Now this, Lordship turns to page 373 for this para 12D of the instructions. This is 373 of the main paper book, the writ appeal paper book.
Not the judgment.
Same volume as the judgment, my lords. Page 373, volume 3 of the paper book, the main paper book, writ appeal paper book.
Yes.
The paper on general English is a qualifying one, and the standard of this paper is that of secondary school certificate. Now, what the learned single judge does is mistakes this to be same as rule 15.5, that para 15.5, I read out the web note, which said that rejected, invalid, disqualified candidates will not be issued. He conflates the two things and says you're contradicting yourself. Which is the para where he says that? On this qualifying. If your lordship turns to para 323, page 291, he makes a mistake about this provisional mains mark list.
Para?
Para 323, it starts, the issue starts.
Yes.
The notification para 15 under the head Memorandum of Marks Rule 15.2 reads as follows. The marks list of the main examination of all candidates will be displayed on the Commission's website. However, paper-wise memorandum of marks of all candidates can be accessed in their respective logins for a period of 1 week. 15.3 was already read out. Request for recounting will be considered for conventional type. Then 324. The Commission, as per the above rules, ought to have published the total marks of all the candidates along with the provisional subject-wise marks. Without doing so, the Commission sent individual subject-wise to the individual logins, which is incorrect, arbitrary, and violated their own rules and regulations. Well, there are two lists. One is the provisional marks list, and the other is the main mark list. That's the final list. What the single judge does is conflates the two things. That confusion comes through in para 325. The Commission, without accepting their mistake, tried level best to cover the said mistake and stated as follows. Para 15.3 did not mandate publishing one consolidated list of all candidates reflecting total provisional marks obtained by them. It only mentioned publishing provisional marks list. So your Lordship keeps the provisional marks list in mind, which published on the respective account of each candidate, and also not only that, the final list reflecting total marks of each candidate after completion of the process of the recounting was published on the Commission's website in compliance with para 15.2. One way the Commission stated that Rule 15.2, the notification did not mandate publishing of a consolidated list of all candidates along with their total marks. This is provisional. He omits the word provisional. There was no mandate for provisional list to have all the candidates' marks. And on the other hand, they stated publishing the total marks of all candidates after recounting on 33 is in compliance with 15.2. So what the judge does is a confusion. He does not keep in mind there's something called a provisional marks list and something called the mains marks list. And he thinks the Commission is contradicting itself. It's actually the judge not clearly understanding that the requirement for provisional is different from the requirement for mains. So this is again another confusion that the judge has. So para 328, while providing an oral explanation regarding this aspect, the Commission stated that the non-disclosure of the provisional marks list would not cause any loss to the candidates. However, the reason given by the Commission is not convincing. If candidates intend to apply for a recount, they need to know both their own marks and the total marks. Well, so recount, what do you need? For a recount of your own paper, why do you need the marks of other candidates? So there is some conceptual confusion here, which is unfortunate because that has steered the learned judge of the course and made him conclude that everything is arbitrary, illegal, violation of the rules. In fact, rules, wherever rules have been specified, rules have been scrupulously followed. So there was an area where the Commission had its discretion to formulate an appropriate procedure, which it did. And like Mr. Shankarayan said, it made the effort of disclosing what that procedure was. And now it's trying to be hoisted on that, saying, oh, you've disclosed this, you've not followed it. So, well, as last is one judgment. Several judgments have been read out, but one is a judgment of this court, which goes by the name of Mowgli Kinnara. I am citing it only because it's very close to the facts here. It's a judgment of the division bench. My Lord will see that. It's being handed over. So here was a challenge to a medical MBBS first semester evaluation, which came to this court. Yeah. Para 8 is important. Yeah. Learned Standing Council, my Lord, has para 8. Learned Standing Council of the University has produced the minutes of the meetings of the board and placed heavy reliance on clause 7. It is resolved that digital valuation of the question papers is approved. Double valuation is mandatory. discrepancy in the total two valuations of more than 15% is set for third valuation, identical to our case. If no discrepancy, then the average marks obtained in double valuation is taken as final. In case of more than 15% variation, the third evaluator's mark nearer to the original evaluator is taken into consideration and an average of the original and the third evaluations is done. Average of three evaluations is to be taken. This is approved with the members of the so-and-so. All the examiners have deputed for final digital evaluation can discuss and set guidelines. So the same procedure, that is, there will be two evaluators. If the difference is more than 13%, 15%, it will go to the third. And there again, Sanjay Singh was referred to, para 16. So far as the judgment of the Supreme Court in Sanjay Singh is concerned, it deals with the aspect of examiner variability. The Supreme Court opined that some procedure should be adopted to reduce examiner subjectivity or examiner variability. The respondents have adopted such method of decision, and pursuant to that, the third evaluator gave the marks to the appellant. Thus, no fault can be found in the deemed order. So, the Sanjay Singh, if you apply, then there's absolutely nothing more to be done. So, going back to that operative portion, if I read out, first mistake is ordering re-evaluation. Second mistake is saying for moderation follow Sanjay Singh. Both were erroneous directions of the learned single judge. Lastly, the broader picture, I think Mr. Shankaran has already adverted to this. The last election was 2011, prior to the formation of the state. We are 14 years down the line. If this kind of an interference is to be tolerated and not on some egregious, serious malpractices, nothing of that sort, you are again going to put off this election by some years because this takes time, Alex. The scale at which, because it's 562 posts, in-service candidates can also take this exam. Because I asked them, why are they so agitated about all of this? They are not going to get this many vacancies advertised hereafter because it's all accumulated from last 14 years. So their chances definitely, if there is a further examination, the chances would come down, which is why there is so much challenge to this. But what it is doing, the administration state is something else. If you don't have group 1 officers at that entry level, then everywhere down the line, because those persons who were there in these posts have all got promoted. You can't have the come down to a standstill, madams. That is something your lordships will have to keep in mind for the scale of this size, selection of this size, and what it does to the morale. Many people have waited for 11 years. Some of these candidates who qualified in the earlier examinations, whether the paper leak and all of that. And how long are they supposed to keep writing exams? For no fault of theirs, somebody comes to the court and says, set aside this entire exam, which is very, very unfair, to a large number of people whose future now depends on this. And it's not good for the state. So even from the point of view of public interest, the learned single judge should have kept that uppermost to say, am I going to just have the entire selection set aside? The consequences are very serious. And we didn't get into the cost of holding these exams. I'm sure it's run into some crores. I don't know. But if you're employing 351 examiners, setting papers at 2 levels, preliminary and mains, evaluating all of that, it must be a massive exercise. So just to very casually say that let's have this whole thing done again was completely unwarranted under 226. That's about it, Manas. I'm obliged.
Everybody is pointing at me. This Urdu medium candidate got more marks. Urdu medium candidate got more marks. I am the Urdu medium candidate. In the writ petition, paragraph 24, they specifically quoted my number, my marks also. How the petitioners, their range depth seems to be more higher than the public service commission as well as the government also. The number of purloined papers that has been filed here, confidential papers, nobody cares how they got it. My number was noted, my marks was also given 81.15, this girl has got it. She is a Urdu medium candidate. How did she get so many marks? Is a malafide intent. That is what was the allegation in the writ petition. To that extent, I will bring to your lordship's time notice, and I will not take much of your lordship's time. I have given my written submission, return submission. That is dated 8/10/2025. That is valid against my return bill is 10/54 of 2025. Shagutta Firdaus. I don't want to repeat what all that been stated, but by cancelling the whole return number 1054 even 1054. Facts matter is already stated. I don't want to repeat. What after Richara? Only memo. That's all. Like what my learned senior counsel Muralidhar has stated, the conclusion is contrary to West Bengal versus Paisaki Bhattacharya's case. That was decided on 3/4/2025. So far, that was the questions of law, Your Lordship could see 5-6 questions framed, whether the wholesale revaluation conduct can be directed without findings of a systematic, unsegregable illegality, whether Sanjay Singh's mandates a single moderation method or merely explains internal moderation, whether suspicion from renumbering or centers allocations equals illegality, whether single judge's order is contrary to Paisaki Bhattacharya that is reported in 2025 SSC Online SC 719, which requires investigation-backed systematic malice before scrapping the process, whether the relief granted is disproportionate and offends Articles 14 and 16, whether the impugned order violates the principles of natural justice, in as much as the appellant's marks and particulars were discussed and allegations were made against her, even though she was not included as a party. I took leave and filed this with appeal. Then, Paisaki Bhattacharya student, that is also I have filed. Paisaki Bhattacharya. 2025, I have given that slip. Certain paragraphs I will read to your Lordship. This is the latest judgment as to under what circumstances the entire system can be cancelled. Although in this case, they have affirmed that the cancellation of the entire process is legal, but kindly see the effort which was made by the West Bengal government is coming to that conclusion. Paragraph 3. I'll only read relevant paragraphs, that I will not trouble all of it.
Yes.
The impugned judgment dated 22/4/24 en bloc sets aside the 2015 selection process conducted by the West Bengal Central School Service Commission for the recruitment of non-teaching staff in Group C and D and assistant teachers for classes 11 and 12 as well as classes 11 and 12. The appellant before us are the selectees, some of whom have been working for over 5 years. They fall into two categories: one, selectees which purported evidence and material indicating wrongdoing, and two, other selectees who claim that they were validly selected and have committed no wrongdoing. The state of West Bengal and the West Bengal Public Service Commission have also challenged the impugned judgment. The respondents before us are the writ petitioners who have succeeded before the High Court at Calcutta. The Central Bureau of Investigation, which had carried out the investigation pursuant to the direction given by the High Court at Calcutta, is also arraigned as respondent. Then I will take your Lordship the factual matrix. Your Lordship would see paragraph 6. Then, my lord, if your Lordship go to subparagraph 6, my lord, in that paragraph, it starts like candidates neither in the merit list nor waiting list were given appointment and also joined. Below that, my lord, when questioned, WSSC stated that it could not verify the number of illegal recommendations. My lord, got it. These are the facts on those cases. None of those facts are present here.
But you need not go through them.
Very well, my lord. I take only such certain portions, my lord. Not all, my lord.
Principles are summarized at para 19.
My lord.
after dealing with the precedents.
Para 19, yes. Illegalities, I'll take one more minute. Para 19 and 20 minutes. The following principles emerge from the opposite decisions. All the decisions that we discussed, whatever that Sanjay Kumar, Sunil Kumar, etc. When an in-depth factual inquiry reveals systematic irregularities such as malice or fraud that undermine the integrity of the entire selection process, the result should be cancelled in its entirety. However, if and when possible, segregation of tainted and untainted candidates should be done in consonance with the fairness and equity. 2. The decision to cancel the selection en masse must be based on the satisfaction derived from the sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable doubt. The standard of evidence should be reasonable certainty of systematic malice. The probability test is applicable. Despite the inconvenience caused to untainted candidates, when broad and deep manipulation in the selection process is proven, due weightage has to be given to maintaining the purity of the selection process. Individual notice, etc. Illegalities in the present selection process. In our opinion, this is the case wherein the entire selection process has been vitiated, tainted beyond resolution, manipulation and frauds on a large scale, coupled with the attempted cover-up, have dented the selection process and beyond repair and partial redemption. The credibility and legitimacy of the selection process are denuded. The High Court has referred to the illegalities in the impugned order as under. In this one, learned single judge was appointed as a commission to go into the malice, and then the report was given. Based on the report, this was being framed. None of those things happened here. Neither any selection process has been vitiated, nothing. Like he had just borrowed the seniors who argued before. It's only a presumption on a presumption that the Urdu medium candidate, one girl got so much and this girl did not get so much. Does not meet the requirement of law under the West Bengal's case. So para 19 and 20 would be relevant. They have given the principles on which it could be set aside. Then in my memo, I have given a table. Your lordship may kindly see. Issues for consideration is D. That's the issues. One, English qualifying marks. I have given a table and also the relevant case laws. What was the petitioner's allegation was non-qualifying candidates in English were considered. TGPSC defense was English was qualifying, only those who failed were excluded. Appellant's contentions, no proof was given. One ineligible selective conjecture cannot vitiate the statewide process. The case law is Rajesh PU versus State of Kerala versus 2007 15 SCP 157. Then the second, moderation in evaluation part of it. Again, the petitioner's allegations were no moderation reliance on Sanjay Singh's case. Double evaluation, third evaluation or disparity closest average rule, that's the defense. Appellant's content, Sanjay Singh illustrates moderation but does not judicially hardwire one method. Substitution by court is equal. In addition, in Sunil Kumar versus Bihar Public Service, they have distinguished that Sanjay Singh's case. Case law also given Sanjay Singh versus UP as well as Sunil Kumar's case. Then the third one was new numbers in mains imply manipulation. Continuous sequence use uniformly trimmed numbers. Appellant, our contents is standard administrative practice.
Did not read them. These are again covering the same aspect.
Only I just given a table wise.
We'll go through it.
This table would be useful to you lots along with the principles laid down in West Bengal versus Baisakhi's case. That was not followed. That's my request. Then going through the findings, will be the repetition part of it. That repetition part of it I don't want to do it because these are all same. Only this judgment of Baisakhi's was delivered in April 2025. Giving the entire scheme as to how the entire selection process if it is vitiated. Neither there is any commission, nor the learned judge appointed any commission, nor was there any internal effort, nothing was there. Except Urdu medium candidate, she was 18 and 9, 17 and 18 belongs to woman candidate, I got the marks, I was 18th in the rank.
You were in center 18 or 19?
Yes. And I succeeded on my own merit. I don't have any allegations of, but as your lordship said, there is not a single allegation of malpractice, single allegations of any corruption, nothing was there. A blank writ petitions were filed. And one thing which I would like to point out to your lordship, my lord, if your lordship sees the writ petition filed in the verification part of it, I'll take your lordship, my lord. This Rajesh Matta's case, if your lordship sees, my lord, that's the lead case. They say so many things, but when it comes to the verification part of it, he does not disclose how did he get so much material. He does not disclose how my marks were disclosed to him. He does not disclose how the confidential internal communications from Public Service Commission to government he got it. Nothing, except says that on my personal basis I got it. My respectful submission, my lord, that verification itself is a false verification. On this ground, all the writ petitions are same on the same aspect. Verification we got. In fact, my lord, all this compilation which my Public Service Commission has filed, they were filed actually by the writ petitioners. That much range and depth they have got it. Therefore, my lord, on that basis, this appeals may kindly be allowed. As of now, my lord, we have completed our training and we are working. 15 minutes have taken, that's all.
Thank you. Few clips. Yes, anything more?
I appear for the commission in items 110 to 116. The commission has argued the lead matter through the learned advocate general without repeating anything that was placed. There are 2 or 3 factual issues on which certain material placed before the learned single judge adverse to in the order may also have to be shown to your lordship for the purpose of showing that there was no systemic error and that the findings returned by the learned single judge possibly are not correct. Lord, the first, if I may just show, my lord, this was also placed before the learned single judge. Your lordships have been shown, my lord, the answer sheets at page 1014. Now, just for your lordships to have, my lord, a quick view of the actual answer sheet. My lord, these are specimen answer sheets that were also produced before the learned single judge. If I may just explain.
Yes.
My lord, this is the mains answer booklet.
Yes.
Lord, the reason I am placing a physical copy is for your lordships to have, my lord, a view of the perforation and how it can be torn off, because, my lord, this explains the system that was followed, my lord, to the Public Service Commission. Lord, if my lords had that answer booklet, Lord, my lords would find on the top right hand corner one perforation that could be used for the purpose of tearing off, my lord, the top 1/3.
This is only a specimen. We can write something.
Yes. Your lordship.
Yes.
But may I continue after lunch, my lord? I may take about 10 minutes at the most. I understand, my lord.
Post lunch, we would concentrate on the other side.
I'll take 10 minutes and come. Maximum. Or if your lordships would grant me the indulgence, I don't want to argue before a hungry judge, because they say hungry judges are sometimes angry judges. 10 minutes.
Post lunch, Muller, there are some 2-3 battery of lawyers, Muller, will take 3-4 minutes, not more than that. After Muller, the land senior counsel, Muller.
So do you feel that we have not understood?
No, Muller, it's not that.
In fact, it could lead to oversaturation of.
We know, my lord, it's a marathon argument, so take
What is
3-4
that?
minutes, everything is
We
covered.
only need 3 minutes of your also.
Yes.
Not
Individual appeals
Yes.
by you.
Yes. No, I am for the successful candidate respondents, my lord, who are already undergoing training.
So there is
Few points supplement, my lord, which are not covered.
you could give on a piece of paper.
2-3 minutes, my lord, for my satisfaction, my lord, say something like that. An important valid point, it's not the case of for arguments, sake of arguing. 2-3 points, I'll enlighten my lord, the bench for 2-3 minutes, my lord.
Satisfaction of those who are behind.
No, my lord, not there, online, my lord, thousands are there.
Now they need not be behind, they are everywhere. They are now watching throughout, my lord. The moment we go home, 100 phone calls are coming. This point we should have brought out, this point we should have brought out.
So, of course, subject to few minutes what
Yes.
the learned councils want to consume, then you would commence. Thereafter, you.
Then, TDS other value will be after the
Three.
tomorrow in period
Tomorrow, of course, it would depend after the senior concludes or time left after he concludes today. So, we just trying to understand there are 3 sets of counsels from the writ petitioner side.
Yes.
There are about 5 your lordships.
3 of you are speaking, rest of them.
Two from our side. Two from our side.
Your side means writ petitioners.
Yes.
There are in total, Lord, there are 6 senior advocates on the writ petitions, and I do not know how your Lordship directs us to.
No, but our previous order
I understand.
indicated that 3 sets from the writ petitioner
We
side.
leave it there. I'm only trying to bring it to your Lordship's notice, saying that there are 6 senior lawyers on this side.
Sure. Very good.